Hello, IP friends. Welcome to another episode of IP series with Rita and Richinda. Now, if you haven't listened to my last episode where I had a guest, Eliana Torres, come talk to us about NFTs, blockchain, metaverse, and the role of IP in all of this, please do check out episode 74. And you know how we do it here. We talk about everything intellectual property related, from copyright, trademark, patent, industrial design, trade secrets, geographical indication, and plant variety. So if you have cases you want me to review, if you have trends, just send me an email to ipseriesinfo@gmail.com. Also follow me on my social media handle at ipseries1 on Twitter and at ipseries_with_reader. Reader is REEDAH on Instagram, and just look for IP series on Facebook. So yeah, welcome to today's episode. This is another throwback edition. So you know that as an intellectual property owner, you have to be proactive in terms of monitoring how your creativity and your innovation is being used. Now, in the event that you find out someone is actually using any elements of your intellectual property, what would be the first point of call or action for you to do? Would you opt for a social media call out? Would you talk to your lawyer? Or would you sue the hell out of the infringer? That is the alleged infringer. So today's episode is talking about what you can do. And, we'll start from talking to your lawyer. I'm a lawyer, so I'm going to say talk to your lawyer if someone infringes on your work. So our case study for our throwback series is the Haribo GmbH Co. KG against Ositos Co, also known as Little Bear Co. So in 2020, Haribo, who happens to be a multinational confectioner, sued an alcoholic sweet in the shape of a bear. Now, Sam Jones had referred to this as a small, sweet bear with the capacity to inflict a very sore head. Now, this Spanish alcoholic gummy bear firm was shocked that Haribo had issued them a cease and desist letter demanding that they stop production of their gummy bears, alcoholic gummy bears. They also handed over their trademark plus their domain name, and they were very upset about it. So today I'm just going to talk about when to use a cease and desist, what trademarks are, what a domain name is, and why brands in every sector should consider having or owning their own domain name. Now, Haribo had spoken to their lawyer, like, look, there's someone infringing on our product, and Haribo has been in existence since 1922. That's a long time, guys. So they were making this demand saying, oh, Ositos Co, which is like the company that made the gummy bears, should stop manufacturing and selling its boozy bears. They should transfer management and ownership of its domain name to Haribo, and seize all promotional material and cancel their Spanish trademark application. Now remember that trademark is territorial in nature, so they were like, why do we have to actually do this? So what is a cease and desist letter? Now, this is more or less like a pre-notice or a notice warning the alleged infringer that, hey, look, you're using my intellectual property without my consent and I do not appreciate it. I want you to stop using my work without my consent. It's also like the very first step when you're dealing with intellectual property theft. It's usually sent to the individual or individuals or group, company, whatever, using the intellectual property right or commercializing or exploiting the exclusive right that is accorded to an intellectual property owner without their consent. You're also requesting them to stop and refrain from using your intellectual property in eternity. And if you've ever gotten one of those, you know how it goes. You get the letter, you send it back to your lawyer to review, and then you guys come up with a response whether to continue or like bring it on, some stomp the yard thing. But yeah, that wasn't the case here. So what do you do when you get one? Like I said, contact your lawyer to help you vet it. Now, because this was a Spanish case, we know that intellectual property mechanisms such as trademark, copyright, patent, design rights are all territorial in nature. So the Spanish trademark law is what will be applicable here. Now, as we know, trademark as an intellectual property mechanism is territorial in nature, and it could be the word, the sign, slogan, shape, sound, smell, or symbol used in relation to your business. Now, trademark protects brand names, symbols, words, signs, and in Nigeria, this is governed by the Trademark Act. And because, like I earlier stated, this is a Spanish case, this is governed by the Spanish Trademark Act. How do you protect your trademark? You do so first by registering your trademark in the class that is aligned with your business. By doing so, you become the owner of the mark and enjoy the exclusive right to use it as for commercialization purpose, to license it, to sell it. It also discourages third parties from using your mark so that there is no likelihood of confusion. Now, when I had posted this picture, I did like a side-by-side of the Haribo gummy bear and the alleged infringing alcoholic gummy bear. Now, I had done the poll and 80% had agreed with me that the two gummy bears looked alike, while 20% said no. And I was like, like, it's glaring from the picture. Then thirdly, having a trademark helps a business trademark to be applied nationwide. And you're not just limited to Nigeria or Spain or the geographical area where your business products or services are known. It also provides like nationwide notice that you are the owner of the mark, because trademark is territorial in nature. I also did another poll and I asked, do you think for a brand like Haribo, who has been in existence since 1922, they are doing the right thing? Just one person answered, and the answer was yes. I think they're doing the right thing because as a trademark owner or the owner of an intellectual property work, you have to be proactive. You have to monitor how your work is being used. You also have to make sure that people are not taking advantage of your goodwill and reputation. Now, this brand in question, that is owned by Ositos Co, was just 1 year old in 2020. Whereas in the case of Haribo, they recently, and that was sometime in July, celebrated 100 years as the world's first gummy bear. Now, according to a publication by Michael B. Stewart, he says Haribo's flagship product is available in more than 100 countries with 160 million Haribo gummy bears being shipped from its factory around the world every day. So you can imagine. Now, despite being this old, Ositos Co decided that they were going to, come up with their own version of an alcoholic gummy bear. I mean, it would have been much better if they had gone to like a collaboration, like creating like a limited edition of an alcoholic gummy bear. So it said that the Ositos Co gummy bear has about 15% alcohol, and 6 gummy bears of that equals to a glass of beer, while 15 gummy bears are equivalent to a martini. So So, what are the components of a trademark? First, you must consistently use the mark in question, and it must be for commercial purpose. So you're consistently commercializing the use of your mark. You don't just register a mark and then just sit, and you also have to pay your renewal fee. Failure to do that, someone can apply that, it be cancelled. A trademark doesn't exist in a vacuum. It must be attached to something for commercial value. Then, when it comes to trademark principle, when processing a trademark application, you must be specific as to describing the goods and services, the functionality, the relevant industry in the right classes according to the NICE classification. When you talk to your trademark attorney or the trademark firm you are hiring to register your trademark, they will tell you all about the NICE classification. Also, apparently, Haribo is saying that all they want to do is protect their registered trademark, their intellectual property rights, their image, and that they have no intention of entering into the alcoholic sweet market. So I did a Google search prior to this recording, and the only news about the alcoholic gummy bear was from the 2020 publication, and I guess they eventually heeded to Haribo's cease and desist. But for a brand that has been in business for about 100 years, the question now is, how did they do it? That they've had, maybe initially when they started, they did not consider trademark protection for their gummy bear, but eventually, so you can imagine that, just like I said, like the components of a trademark is you have to commercialize it consistently. You have to consistently use it for commercial purpose at the end of the day. And the funny thing is that the Ositos Co gummy bear, it's actually, the shape is just like the Haribo gummy. So you see the Haribo gummy bear, that's how Ositos Co gummy bear is. But the difference is that it's alcohol induced. Now, in their argument, that's Ositos Co argument, they stated that a bear is an animal in the woods, and I was like, is that the only animal in the wood? I mean, there are several other animals that you could have chosen for your gummy bear alcoholic brand, but you chose to do the exact gummy bear that Haribo's have been in business. Now, brief history of how Ositos Co came up was that, they're like, what if we combined our childhood love of sweets with an adult taste for alcohol? It's like mind-blowing, right? And you're like, oh, right. Because IP doesn't protect ideas. And then you're wondering, how do I convert this idea into something? So that was what they actually did. They came up with the idea of, reliving their childhood love for sweets. Came up with the alcoholic gummy bear. 1 year later, you're getting a C and D. This is from Haribo. Now, I had asked the question, do you think this is another David and Goliath fight of a big brand bullying a small brand? Because, this year we've seen a lot of conversation where people are like, oh, this brand is bullying a smaller brand. I'm going to talk about that in my next episode, where I review the House of Zana and the Zara case. And the conversation is that Zara has been going around suing anyone that has a brand with a Z or something that sounds similar to Zara and all of that. But let's move past that. Now, 67% agreed that this was, a David and Goliath fight, which I don't think it is. I think Haribo was just doing their job by protecting themselves. Then 3% said maybe. Now, I asked another question again. Is Haribo just protecting their brand by being aggressive and proactive about their IP? 100% yes. And I agree with the response. Then what can a brand learn from this very short story? Is that you always need to do a search before registering your IP or before coming up with your create. So while you're, going from from the idea stage to the pre market stage, make sure that you do a proper search. Now, I know I'd come across a publication or a write-up where the World Intellectual Property Organization had listed out a couple of things that um, startups and business owners should take note of. I can't get across it now, but I'm pretty sure before the end of this recording, I should have come across it again. So I just found it. So what's intellectual property for startups, WIPO shares the phases. So while you're in your phase of your innovative idea stage, do your search. If you're the market stage, also do your search. It's like, is there anyone similar to what I'm doing in my country or another country? You also, once you've clarified that, then you move to the protecting your creation or your innovation. Then if you're not thinking of it on the bigger scale or long-term goals, you then do like an international registration. Go international, grow your business, consider the risks and then also manage them. Then you also need to learn how to draw the line between being inspired and outrightly copying someone, which is an infringement, because we know that when dealing with intellectual property, consent, permission, authorization is very important. Once you don't have the CPA, you are considered to be an alleged infringer. Then know that intellectual property has value. It really has value. So I'm going to talk about a case that was viral some years ago. And this is because it is very important that brands are up to date with, in registering their intellectual property when they are growing and expanding. Even when you're considering looking for funding, just to be on the safe side, register and protect yourself. So you don't go and, start doing the social media call out and crying. So now there's this case called the Steve Jobs Clothing Company and Apple Inc. over the use of Steve Jobs' name and, Apple inspired logo. So Steve Jobs clothing logo is a J, half beaten J, just like the half beaten Apple. And they used that logo for their clothing and accessory, and this dispute started like in 2020 and was resolved in 2017, where the European Union courts granted the two Italian brothers and their business partners the right to use Steve Jobs' name and Apple inspired logo. Apple Inc. should have considered, a clothing and accessory line, but just like in the Haribo case, now Haribo is like, oh, your gummy bear. We are the only well-known gummy bear, producers, and then you are coming up with this. But then, whatever you do, just don't leave your trademark behind, and always remember that trademark comes from use plus in commerce, which equals to a trademark. 5 things that you need to know about the Haribo gummy bears are: the investor's name is hidden in plain sight. The name is also derived from the original main ingredient, which is gummy, I think. I'm not sure. Then the colors don't always match the flavors, right? And then they are made in a machine called starch mogul. And the halal gummy bears are produced in Turkey. So I came across that publication, which was on the dailymail.com by Dan Myers, who said, so the topic is 5 things you didn't know about Haribo gummy bears, and I kind of find it interesting to share. Whereas on the other hand, Ositos Co is an alcohol infused gummy, available in a 70 gram tins and 120 gram bags, which contains about 15% alcohol with 7 to 9 sweets. I think I already mentioned all of that. Yeah, I did mention that. Now, moving on to the very last issue, which is Haribo demanding that Ositos Co transfer ownership of their domain name to them in their cease and desist letter. Now that's Ositos domain name was Ositos Co N, that's the letter N, alcohol.com. And you may be wondering why. So it turns out that Haribo's effort to, prevent the alcohol gummy bear from, being in business failed. So according to the owners of the alcoholic gummy bear, they said if the season and that kind of helped promote their brand and their own gummy bear. Until date, they have sold 2,213,129 alcohol gummy bears. In his words, they have gone partying. I mean, it's surprising, yeah, because but imagine that gummy bear had actually succeeded, in what they actually wanted. It's very important that brands take all forms of intellectual property protection seriously. Has Haribo over time shown that they have the exclusive right to use the bear shape for gummy based candy? Not sure, but then their goodwill and reputation and their longevity, sort of became a detriment when they wanted to enforce the exclusive right that they have as a brand. Now, domain name is like your online ID or your web address that gives your visitors or your consumers or users access to your brand and company's website. For instance, asos.com. I love to window shop on Asos. Jumia.com, google.com. Now a domain name can comprise of the combination of a letter and numbers. However, it is advisable to choose a name that is distinctive, so your users can easily identify you. Using a common name can be impossible to both brands, and can distort your flow of building a reputation. Also, you have issues where people like use meta tags to derail consumers from going to your actual site and ending up at their own website. And types of domain name, you have the top level domain, which is like the highest level in the domain name structure of the internet. Then you have several other different types of top level domains, such as the country code top level domain. For instance, you have two-letter domain established for geographical locations, e.g. .ng. Then you have generic top-level domains such as .org. Then you have internationalized country code top-level domains. And you have second-level domain, third-level domain, and then sub-domain level. Yeah, so if you don't have a domain name, please consider it for yourself as a brand. Figure out what works for you and then build on that. Now you may be wondering, what is the difference between a domain name and a trademark? Now, trademark protection is territorial in nature, and you only enjoy protection in the country where you actually registered your mark. And it's because of this that a trademark owner cannot rely on trademark protection. As I always tell my clients or people that I have interaction with or consult for, that having a multi-layered IP protection is very important. But while doing that, you also need to consider other things in time, like for instance, now the domain name that we're talking about. Now, I don't know how many of you have heard of ICANN. That's ICANN. So it stands for the Internet Corporation for Assigned Names and Numbers, and it is a non-profit organization that is responsible for coordinating the maintenance and procedures of several databases related to the namespace and numerical spaces of the internet. They also ensure that the network is stable and secure, so that you're able to reach another person on the internet while you type out the address into your computer. Now that address has to be very unique, like I earlier stated, and I can coordinate these unique identifiers across the world. So just Google them up. You can also sign up for their newsletter, very informative. Um, what does ICANN have to do with intellectual property? Now it plays a similar administrative role with the IP addresses used by computers as it does with domain names used by humans. In the same way that you cannot have two domain names, otherwise, you never know where your website or your brand will end up. And for that same reason, it's not possible that there be two IP addresses. So, so Ositos and Co alcohol.com cannot coexist. One has to give way for the other. Now, under the Uniform Domain Name Dispute Resolution Policy, which is referred to as UDRP, most types of trademark-based domain name disputes are usually resolved by the agreement, court actions, or arbitration before a registrar will cancel or suspend or transfer a domain name. So in this case between Haribo and Ositos.com, where Haribo's has said that you have to give us your domain name, so they are basically going to transfer their domain name to Haribo's. And every relationship dispute basically would come out of it, and disputes alleged to be to arise from abusive registration of domain name may be addressed by an expedited administrative proceeding. For instance, you have cyber squatting as one of the abusive registration of a domain name. Some people use that as like it's like business for them. That's what they are just doing. Where someone holds where the holder of a trademark initiates by filing a complaint with an approved dispute resolution service provider to invoke the policy. You must also file a complaint in court of proper jurisdiction against the domain name holder, or where appropriate, or in cases of abusive registration, you just submit a complaint to an approved dispute resolution service provider for further for further information. Check out ICANN's resource page for that. We know that out of court settlements are usually confidential, flexible. They're not, they're not too formal, and it's also party driven and less expensive. And then it also preserves relationship. I don't think Haribo and Ositos have gone a bad way. Maybe they might have, recruited them to be researchers or something, or Haribo might eventually just come up with their alcoholic gummy bear. You never know. But yeah, that's about it for this case. Let me know what you learned from this case as a business owner or as a practitioner. Would you have advised Haribo to issue a cease and desist letter to Ositos? Would you have, preferred that they went into some sort of business relationship? What are your thoughts, guys? Just let me know. Now, in wrapping up, all I have to say is that whether or not you're a big brand or a small brand, it's very important that you consider having a multi-layered IP protection. So the gummy bear, the shape of the gummy bear, the flavors, the colors, the name, the logo, the packaging, everything that makes your gummy bear a gummy bear, or a gummy rather, or a confectionery, or whatever it is. Just consider different IP protection. It might seem expensive, but in order of priority, which one do you think is the most important for your brand? Because as we know, the value of IP can change, and you don't want to leave your IP behind. You want to register and commercialize and monetize it, so that when you get to that point where you can do evaluation, you can also use it for as security or whatever it is. But yeah, make sure you have an intellectual property lawyer or your retainer, just for proper advice and better. But yeah, that's about it for our throwback series. Tell me which of my episodes you want me to do a throwback series and I will consider it. Don't forget you can send me an email to ipseriesinfo@gmail.com. Follow me at ipseries1 and at ipseries_with_reader. Anyways, see you guys in the next episode. Don't forget to listen to the previous episode as well, and also reading my last newsletter on the Barlow and Bear Necklace dispute over the unofficial Bridgerton musical. And yeah, have a fab day, guys. Cheers, bye.